now look at the Mischief rule. The Mischief rule is also known as the rule in Heydon's case. According to this rule, the courts ascertain the intention of the Parliament behind the legislation under consideration. The courts consider what was the mischief that the Parliament aimed to remedy. The courts ascertain this in light of the following four principles laid down in the Heydon's case, 1584. Principle number 1. What was the common law before the making of the statute? Principle number 2. What was the mischief and defect for which the common law did not provide? Principle number 3. What remedy did the Parliament propose to cure the disease? And the fourth principle is the true reason of the remedy. The courts are always to make such construction as shall suppress the mischief and advance the remedy, and to suppress subtle inventions and evasions for continuance of the mischief, and to add force and life to the cure and remedy, according to the true intent of the makers of the Act. This rule is used widely, and the rationale behind this is reflected in the following statement of Lord Radcliffe in AG for Canada against Heydon and Carey Limited. Courts of law have resorted to different rules of construction in their interpretation of statutes, but the paramount rule remains that every statute is to be expounded according to its manifest and expressed intention. Since there is always a reason and rationale behind every enactment passed by the legislature, this rule can be applied to any law, wherever literal and golden rules failed to achieve the purpose of the legislation. In the case of River Wear Commissioners and Adamson, Lord Blackburn said, "In all cases, the object is to see what is the intention expressed by the words used, but from the imperfection of language, it is impossible to know what that intention is without inquiring further, and seeing what the circumstances were with reference to which the words were used, and what was the object appearing from those circumstances which the person using them had in view." The more important reason why the literal and golden rules may be considered before this rule is applied is because the courts may have to take painstaking exercise to find out the intention of the Parliament in the case of mischief rule. Now let's look at some of the examples of the cases where this rule was applied. Number 1, Corkery and Carpenter, 1951. Now this is the case where the defendant was riding a bicycle whilst under the influence of alcohol. Under Section 12 of the Licensing Act 1872, it was an offence to be drunk while in charge on any highway of any carriage, horse, cattle or steam engine. The court held that the act was to be read purposively. Lord Goddard, CJ, ruled, "For this purpose there cannot be any distinction between a section in a highway statute passed for the protection of the public and a section in a licensing statute passed for the same purpose, both of them concerning the conduct of a person on the highway and the preservation of public order. And a bicycle is a carriage. It is a carriage, in my opinion, because it carries. The mischief intended to be addressed was drunks on the highway being in charge of transport. The court applied the mischief rule, holding that riding a bicycle on the highway under the influence of alcohol was within the mischiefs the act proposed to remedy. As such, the defendant represented a danger to himself and other road users and was held guilty. Example of R against Westminster Magistrates Court. It's 2011. Relatively recent case. The United Kingdom Independence Party had accepted donations from an individual whose name was not listed on the electoral register through inadvertence. Party could have received donations only from those persons whose names were on the electoral register. The Electoral Commission sought to impose a forfeit of an equal amount under Section 58(2) of the Political Parties, Elections and Referendums Act 2000, which reads, "The court may, on an application made by the Commission, order the forfeiture by the party of an amount equal to the value of the donation." The Court of Appeal applied the literal approach and ordered the party to repay the whole of the donated amount. On appeal, The Supreme Court held that the mischief intended to be remedied was to prevent foreign donors from funding UK political party. The mischief had not occurred. The Parliament imposed a requirement that the name be on the register. However, there was no presumption in favour of any such forfeiture, and property rights should not be interfered with except where such an intention is shown clearly. The case of Smith and Hughes. In this case, the defendants were prostitutes who had been charged under the Street Offences Act 1959. The Act made it an offence to solicit in a street or public place. The prostitutes were soliciting from private premises on balconies or in windows so could be seen by the passers-by. The court applied the mischief rule, holding that the activities of the defendants were within the mischief the act was aimed at. The mischief Parliament intended to remedy was soliciting people on the street, even though the prostitute was not in the street herself. The act should be interpreted to include this activity using the mischief rule. Lord Parker stated that the aim of the act was to clean up the streets to enable people to walk along the streets without being molested or solicited by common prostitutes. If the court had applied the literal rule, the prostitutes would have been acquitted since they were not soliciting in a street or public place. They were within the premises of their private properties. Let's look at another example. Royal College of Nursing and DHSS. The Offences Against the Person Act 1861 made it an offence for any person to carry out an abortion. The Abortion Act 1961 provided that it would be an absolute defence for a medically registered practitioner to carry out abortions, provided certain conditions were satisfied. Nurses were not registered medical practitioners. However, it was common for the abortions to be administered by nurses. The Royal College of Nursing disputed a Department of Health and Social Security statement that it was not an offence under Britain's 1967 Abortion Act for nurses to terminate a pregnancy by medical induction if a doctor decided on the termination, initiated it, and remained responsible for it. The House of Lords, as it then was, ruled that since the intent of the 1967 Act was to broaden the grounds on which abortions might be lawfully and safely obtained as part of ordinary medical care, nurses participating in pregnancy termination were protected under the Act, provided that a physician prescribed the treatment, remained in charge, and accepted responsibility throughout the procedure. It was a controversial decision, with Lords Wilberforce and Edmund Davies claiming that the House was rewriting the legislation and not just interpreting it. This is the end of our construction rules. We have learned the literal rule, the golden rule, and the mischief rule in this section. Please go to quizzes. The link would have been given under one of these videos. Follow the link and you can access the quizzes for free. Let's move on to our next section, which is language rules. See you in the next lecture.